Welcome all, my dear friends. Let us continue our journey in the world of patents. Today's key term is compulsory licenses. Okay, friends, till now we have discussed up to form number 16 and its relevant sections and rules. Okay, so now it's the turn for form number 17. Okay, and the key term for form number 17 and its relevant sections and rules is compulsory licenses. Fine. So compulsory licenses, or what is so here we will try to analyze what is compulsory licensing in a literal way and how it is significant in the world of patents. Okay. Okay, so next, in the next slide we will try to analyze the literal meaning and the meaning in the patent world. Fine, let us proceed. Friends, as we know that the key term for form number 17 is compulsory licenses, so you can see here that compulsory license indicates form number 17. Fine. So now we will see what does it mean literally. Okay. So compulsory means that must be done, plus license, compulsory license. Okay. So what is the meaning of license? License is an official permission to do, use or own something. Now this is the literal meaning of compulsory license or compulsory licensing. Now we will see how compulsory license is defined in case of, or we can say in the world of patents. Okay, so let us see. A compulsory license is an official permission by the government allowing someone else to produce the patented product or process without the consent of the patent owner. Fine. So you can very easily differentiate between the literal meaning of the compulsory licensing and the meaning in the world of patents. Fine. Then form number 17. The title is Application for Compulsory License. Okay. Here the related sections are 84, 91, 92, 92A. And the related rule is only one, that is rule number 96. So we will discuss briefly about all the sections. Section 84 is compulsory licenses. Section 91 is licensing of related patents. Section 92, special provision for compulsory licenses on notification by central government. Section 92A, compulsory license for export of patented pharmaceutical products in certain exceptional circumstances. Fine. And rule number 96 says application for compulsory license, etc. So here the keyword is no need to explain. The keyword here is compulsory license. Fine. Next we'll proceed to form number. Today I have taken section 91 and this comes from chapter 16, and the title for chapter 16 is Working of Patents, Compulsory Licenses and Revocation. Okay, and friends, just take a look here. The title for section 91 is Licensing of Related Patents. Okay, licensing of related patents. So let us proceed with the further slides where we can have a detailed explanation of this section. Okay. Okay. The keywords for subsections of section 91. Okay, so I have picked some key terms or key phrases from the subsections of section 91 as per my intellect. Okay, so please you can choose your own and try to remember these key terms, and with remembering these key terms, please try to recall the essence of the respective subsections of section 91. Fine. So let us take a look. For subsection 1, the key term or the key phrase is after the sealing of a patent. For subsection 2, the key term is no order. For subsection 3, the key phrase is a license under the first mentioned patent. And for subsection 4, the key phrase is provision subsections 87, 88, 89 and 90. Fine. So, let us try to remember this key terms or the key phrases, and let us proceed to the details of the respective subsections. Okay. Subsection 1. This says, notwithstanding anything contained in the other provisions of this chapter, at any time after the sealing of a patent, any person who has the right to work any other patented invention, either as patentee or as licensee thereof, exclusive or otherwise, may apply to the controller for the grant of a license of the first mentioned patent on the ground that he is prevented or hindered without such license from working the other invention efficiently or to the best advantage possible. Okay, so friends, as we are dealing with related patent applications in this section, so let me first tell you the literal meaning of the related patent applications. Okay, or when does these applications are filed? Okay, so just I am giving a just I am giving a brief of this type of applications. Fine. Okay, listen carefully. Related patent applications are filed after the original application is made but before the patent is issued. An inventor might want to file a related patent for a technology that improves on the initial design. This allows him or her to avoid filing a new application. Fine. So now let me analyze this particular subsection. Okay. So in a very simple way, I can analyze this subsection is, just listen carefully. Okay. After sealing of the patent, at any time, any person having the right to work any other patented invention as patentee or licensee may apply to the controller for granting of a license of the first mentioned patent. Then what is the ground? The ground is the applicant is prevented from working the other invention efficiently without such license. Okay, this is the ground or the reason for which this type of applications are filed. Fine. And we can say, friends, here some relevant rules to this particular subsection are rule number 62, whose title is hearing; rule number 92, whose title is registration of titular interest in patents; rule 93, the title is entry of renewal fee; rule 94, its title is alteration of address; rule 95, whose title is inspection of register of patents under section 72 and fees payable therefore; and at the last, rule number 96, whose title is application for compulsory license, etc. Fine. So we can say here, just I am reading the subsection again, just take a look. Notwithstanding anything contained in other provisions of this chapter. Of this chapter means chapter 16. Okay. And as we know, chapter 16, just a second, friends. Chapter 16 is working of patents, compulsory licenses and revocation, that we know. Okay. So without, or we can say notwithstanding anything contained in the other provisions of chapter 16 at any time, but after the sealing of a patent. The condition is after the sealing of a patent, any person means who? Who has the right to work any other patented invention. Okay, either as a patentee or as a licensee. And the licensee may be exclusive one or otherwise. Fine. They may apply. Okay. That means either the patentee or the licensee may apply to the controller for the grant of a license of the first mentioned patent on the ground that he is prevented or hindered. That means the reason or the ground is that he shows that he is prevented or hindered without such license from working the other invention efficiently or to the best advantage possible. As he is not getting the best advantage, that's why he is applying for this kind of application. Okay. So I hope it is pretty much clear now. We can proceed to the next subsection. Fine. Subsection 2 says, no order under subsection 1 shall be made unless the controller is satisfied, clause 1, that the applicant is able and willing to grant or procure the grant to the patentee and his licensees, if they so desire, of a license in respect of the other invention on reasonable terms, and clause 2, that the other invention has made a substantial contribution to the establishment or development of commercial or industrial activities in the territory of India. Okay, so here the key term is no order. Okay, and the situations are mentioned in the clauses. Okay, so let me explain this in a very simple way. Just listen carefully. Order is made. What is mentioned here in the subsection? Here no order is given, but I am explaining it in a positive way. So try to listen and understand. Okay, again I am reading, or again I am telling. Order is made only when the controller is satisfied that, point number 1, the applicant is able to grant to the patentee and his licensees, if they so desire, a license with respect to other inventions on reasonable terms. And the operator is and. Point number 2, the other invention has made a contribution to the establishment or development of commercial activities in Indian territory. That's all, friends. This is the very we can say the simplest meaning of this subsection. So I hope it is pretty much clear now. So let us proceed to the next subsection. Subsection 3 says, when the controller is satisfied that the conditions mentioned in subsection 1 have been established by the applicant, he may make an order on such terms as he thinks fit, granting a license under the first mentioned patent and a similar order under the other patent if so requested by the proprietor of the first mentioned patent or his licensee, provided that the license granted by the controller shall be non-assignable except with the assignment of the respective patents. Okay, so here the key phrase is a license under the first mentioned patent, and another we can say the secondary key term is non-assignable. Fine. So let me explain this subsection in my own way. Okay, just listen. The controller may make an order when he is satisfied that conditions mentioned in subsection 1 are established by the applicant and grant a license under the first mentioned patent and under the other patent if requested by the proprietor of the first patent or his licensee. The license shall be non-assignable except with the assignment of the respective patents. That's all, friends. This is the essence of this subsection. I hope it is pretty much clear now. Okay, so let us proceed for the next subsection. Subsection 4, and this is the last subsection of section 91. Okay, what does it say? This says the provisions of sections 87, 88, 89 and 90 shall apply to licenses granted under this section as they apply to licenses granted under section 84. So the simple meaning is that the provisions of sections 87, 88, 89 and 90 shall apply to licenses granted under this section in the similar way they apply to licenses granted under section 84. That's all. This is the simple meaning of this. Okay. So the relevant sections are Section 87, whose title is Procedure for Dealing with Applications under Sections 84 and 85. Section 88, whose title is Powers of Controller in Granting Compulsory Licenses. Section 89, and its title is General Purposes for Granting Compulsory Licenses. Section 90, whose title is Terms and Conditions of Compulsory Licenses. That's all, friends. So this way all the subsections of section 91 are completed. So please go through each and every subsection. Try to grasp the essence of these subsections, and you can refer the direct as well. Okay? Okay then. So we have heard about the terms like voluntary license, compulsory license. Okay? So let me just compare between the two. Okay? So what is voluntary license? Voluntary license is an official paper that shows you are allowed to do or have something, or you have the permission to enter or use the property of another. Right? This is a simple. That means license means, in normal terms, whenever you utter the term license, it is voluntary license. Fine. And then what is compulsory license? Compulsory license, it is a legal document by which a bank, building, society, etc. lends money at interest in exchange for taking title of the debtor's property, with the condition that the conveyance of title becomes void upon the payment of the debt. Fine. So I hope now you can differentiate between these two. Fine. The reference is Patents Act 1970 as amended by Amendment Act 2005, and the Patents Rules 2003 as amended by Amendment Rules 2021. So friends, please like, share and subscribe the channel. Thank you all for listening to me, and thank you all for watching my video. Stay safe, stay blessed. God bless you. Jai Hind.